Good day and welcome to this week's episode of Strictly Legal on WESN Content Capital. I am your host, Rondell, Donawa, attorney at law, and I am glad once again to bring the law and you. Today we have a very, very important and informative topic dealing with common law relationships or cohabitational relationships. Of course, you know, in Trinidad and Tobago, many persons live in common law relationships. And you want to know what is your rights, what is your entitlements with respect to whether there are separation or death of a common law spouse. And today in studio, I have a very distinguished guest. Her name is Mrs. Karen Nunez-Tesheira. Many of you know that she's an attorney at law, or you may have known that she was a former member of parliament and the Minister of Finance. However, in this particular scenario, she is first and foremost an attorney at law who specializes in law of employment, probate law, and family law. Now, she's an author of 3 Commonwealth Caribbean legal texts targeting the law student and practitioners alike. The first, a non-contentious probate practice and procedure, first and second edition, and the second on the status and ethics of the legal profession, and more recently on the Commonwealth Caribbean family law of the husband, wife, and cohabitant, published by Rondell, a renowned international publishing company as part of their Commonwealth Caribbean Law series. Now, Mrs. Nunez-Tesheira has also conducted several business law workshops for companies within the region. For almost 20 years, Mrs. Nunez-Tesheira was the course director for the period 2003 to 2007, and also the senior tutor at the Hugh Wooding Law School. For the periods 2007 to mid-2010, you will have known her as a member of parliament, as well as the first and still the only female Minister of Finance in the government of Trinidad and Tobago. And of course, moving forward from there, she continued lecturing at the Faculty of Law, UWI Cave Hill. So Mrs. Tesheira, through her several years as a teacher of the law, both at the Faculty of Law and the Hugh Wooding Law School, and in particular through her publication of legal texts, of course, which I do own, has maintained an unwavering commitment to the development of Caribbean legal education and the realization of a truly Caribbean jurisprudence. Welcome, Mrs. Nunez-Tesheira.
Oh, that was a mouthful.
I know it was.
I have a feeling I gave you too much to read. I didn't know you were going to read out all of that.
It was. But
I'm
it's
happy
interesting
to be here, and of course, I'm sure a lot of my former students, whether at the law school or at Faculty of Law, welcome to them too, if any of them are watching on. I'm happy
yes,
to be
exactly,
here.
Because there are a lot of your students here,
yes.
of course. And
I enjoy teaching them very, very much.
Indeed. So let's get right into the topic,
yes.
of course, because, of course, you know, our time is limited. So tell us, what is a common law or a cohabitational relationship?
Right. So let's make a distinction, because what it is called is as a statutory spouse or cohabitant, because when we use the term common law, it's really a rather loose definition, and it's how we probably would have referred to those relationships where persons live together and were not married in the sense of a legal marriage, what the law would recognize as a legal marriage. So we refer to them, and we still do refer to them as a common law spouse. But for purposes of intestate succession, meaning your inheritance rights, it certainly becomes important to decide that you're no longer just a common law spouse, but you're a cohabitant. Also, if the relationship breaks down, whilst the other party to the relationship you all decided to go your separate ways, then the issue of what is a cohabitant becomes also important as defined by the relevant legislation for maintenance or making a property adjustment order, meaning that the property might be in the name of the other cohabitant only, and you're saying, well, I think based on X, Y, Z, that I should have a share of that property, or given a lump sum order. So the term common law is a term that is used in reading newspapers. We say it all the time, but yes, it takes on a special meaning when you're dealing with inheritance rights and when you're dealing with maintenance applications and property adjustment applications.
So let's deal firstly with maintenance rights of the cohabitant. Yeah. Now, firstly, persons always ask, how long do you have to be living in a relationship in order to be established as a common law?
Well, the thing about it is that under the Cohabitation Relationships Act, which was passed in November of 1998, it is very noteworthy that in the what we usually call the Section 2, which is the clause, the dictionary part, that defines the meaning of a word, the cohabitant, it says bona fide domestic relationship, a man and a woman, so it can't be same sex, it has a bona fide domestic, but they do not tell you the duration of the relationship. It doesn't say for a period of a minimum of 5 years. That is not in the definition either of cohabitant or cohabitational relationship. However, when you go now to make an application for maintenance,
yes,
you have to look at how do you qualify. So to qualify now, it gives you in the legislation, I think at section 7, it says to qualify doesn't mean you're going to succeed. Get the key in the door, door not opening yet. But to qualify, then they tell you a cohabitational relationship of no less than 5 years, or, and additionally, the applicant has a child coming out of that relationship, or the applicant has made substantial contributions.
But it has to be in a continuous living relationship.
Yeah, continuous living relationship, which we don't really have time to really drill down on that because there's a lot of case law on that. But what it says, and there's case law on that, and we could do specifically with maintenance, what the case law says is that it doesn't mean that you have to be living under the same roof to satisfy the test of a bona fide cohabitation relationship. I think the case that really gave a definition is a very famous case. He's now a Justice of Appeal, Mendonca J., as he was in the High Court in Delzine and Stowe. He took it on. He said, you know, there's no statutory, no definition in the legislation. But he said, we took our definition from New South Wales, Australia legislation, and they gave us statutory definition. So he adopted that. So when they tell you bona fide, it means, okay, a good thing is if you're living under the same house roof, that's a good starter.
Yeah.
If whether there's a sexual relationship between you, both of you, whether it's financial or dependence or interdependence, whether you share household duties, whether your relationship is publicly recognized. So there are guidelines to determine whether someone qualifies as a bona fide. So sometimes there's a case where the gentleman was married, wasn't living with the wife, he had another household with children, and for all intents and purposes, the court said she was qualified as a cohabitant. So
okay,
it's harder,
yes,
definitely harder if you are not living under the same household. Definitely a more difficult thing. And also it's 5 years, and you have to make your application within 2 years of the termination. So you have to know when it started. You have to have that starting point.
yes,
And you have to have an ending point of no less than 5 years.
and there must be evidence.
Well, there you go.
Yeah.
And that's where you have to, if you have to go to court, and then you have to make an application within 2 years, although the court has the authority to extend the period. But when you're talking, coming back to your question on maintenance in particular, it's very important that people understand if they're in a cohabitation relationship. And I'll quote directly from section 14. It says, except or otherwise provided by this act, one cohabitant is not liable, you hear the word not, not liable to maintain the other cohabitant, and the cohabitant is not entitled to claim maintenance from the other. So you understand, when it comes to maintenance, you have a little hard road to climb. Yeah. So what is that hard road to climb? Where the law tells you who would qualify, and you'd see how maybe difficult it is.
Yes.
It does not, it's what it says, that you have to be unable to support yourself adequately, not because you just can't support yourself, by reason of having the care and control of a child of that relationship, or a child of the other cohabitant who may not be your child, who is under the age of 12, or has a mental or physical disability which allows you to go up to 18. And then the other circumstance they will also consider is, did you give up your job? Did you give up your career? You were doing a course in hairdressing, you were doing a course in welding, whatever it was, but they want you to stop to stay home and take care of the household. The court will take that into account and give you an order to enable you to complete that education. But also they look at other circumstances, a whole range of circumstances. But at the end of the day, you're not entitled, that the person is not liable. They are very strict about qualifying, and very importantly, the duration of a maintenance order by the law is no more than 3 years.
No more than 3 years, indeed.
So all of those things, when you're looking at, and I would just want to say for the cohabitant, it's not much different now for the legal spouse. The court generally now stays away from making what they call periodic payments. What they make is a clean break order, because they say relationship broke down. Why you have to be going every minute to the court to see if you send money for the children, if you send money that is supposed to, it just keeps a bad relationship that is already broken down ongoing. So let everybody go their way. So even with the legal spouse, there's also that tendency of the court not to want to continue maintenance orders. But the property adjustment order is what
is where, and of course we will talk about that when we return after the break. So you are watching Strictly Legal with Mrs. Karen Nunez-Tesheira. We'll be right back. And welcome back to this episode of Strictly Legal. We are speaking on the common law spouse, the rights and duties of the common law spouse in Trinidad and Tobago. So, Mrs. Nunez-Tesheira, before we were talking about the maintenance aspect with respect to separation, let's deal with the property adjustment orders now.
So, with the property adjustment order, is a little different to qualify. They say a cohabitation relationship of not less than 5 years. So, that's when the 5 years becomes an issue. Or there's a child arising out of that relationship. It could have been 2 years, 3 years. It doesn't give you a time limit, but there's a child. And then the applicant has made substantial contributions. So that's the key. Yes. So now when you're looking to see, well, am I entitled to make not only I qualify to make an application, but am I going to succeed? The Section 10 tells you what are the things they're going to look at, and it's really contribution driven. And by that I mean direct contribution to the improvement or acquisition of the property, or the subject matter of the application. So if you put money into it, you paid towards the mortgage, you made some kind of, you improved the house renovations, that is direct. Indirect, which is recognized both for legal and for cohabitant, is that have you made in terms of taking care of the home, providing homemaker provisions, taking care of children, taking care of the welfare of the home. Now, the big difference and between the two is that the contributions indirect of a cohabitant does not have the same equal weighting as the contributions made by a legal spouse when she's making the same type of application.
Explain about that.
Right. So the case that spoke to that was the famous case of Delzine and Stowe, which I had mentioned. And in the judgment, apart from defining bona fide domestic relation, the judge went to pains to say that the Parliament never intended that the cohabitant and the legal spouse will be put on the same footing when it comes to property adjustment. He said, for example, under the Married Person Property Act, which is what a legal spouse will go to if they're getting divorced and making an application, they look at the needs of the applicant and the standard of living they enjoyed before. He said a lot of those statutory guidelines are missing, and based on the intention of Parliament, as he said it, and followed by all the cases, is the contributions indirect will not have the same weight as direct contributions. If you were a legal spouse, they are equal in weight. The other negative, again, is that if you have made contributions, I expect more of the indirect nature, and the court is of the view that the other cohabitant has compensated you for those contributions, your application is going to fail. And there was a case, I won't call the name of the parties, but they lived obviously in a very upper class area, and he obviously was in a very high, good position. And what did she do? Well, she said, well, I did interior decorating, I made sure I entertained his guests, I instructed the household. So you understand the kind of person we're speaking about. On his hand, he said, I paid for to go to London to go and do a degree, and I paid all the tuition costs, all the costs. And in that case, I think it was Justice Gobin. So I think you are being compensated for whatever contribution you make. Now, if you are a legal spouse, that is not going to be part of the argument. But
meaning non-pecuniary, also pecuniary contribution.
So he said, so she has been compensated. So two things you have to remember. With a property adjustment order in relation to you also have to look at the rights of the legal spouse to that property. See, so there are a lot of, it's not as easy to get through as a cohabitant. It's not that you can't, because in that same Delzine and Stowe, after much argument and whatever, breakdown relationship, he got to get, with the 5 years, he did get some money.
But I want to ask a question. Now, you see, a lot of times persons are married, they are separated, but they have not been divorced. And then they are now in a cohabitational relationship with someone else, living in the house where the spouse was living. And then let's say the common law spouse end up separating, from that particular person who owns the house with his wife. How does that separation
Yeah,
work?
but that's, you see, now, that relevance of
lot
what
of
you just...
complications.
Okay, no.
Yeah.
That relevance of what you just said is more in relation to inheritance.
Yes.
That is more in relation to inheritance. Because once you could show that you are living with this person and you satisfy the bona fide domestic relationship test, once you could say that, and it doesn't require 5 years, it doesn't matter if he has a legal spouse. It doesn't say you have to have a legal spouse. It's a man and a woman. It doesn't say single man and single woman. In some jurisdictions, they will say single man and single woman. And they define single to be a person who's either widow, widower, or divorcee. We don't say that. So you can very
That's
well...
important
Yes, that was a,
distinction.
yes. So what I mean is that you can apply, once you come within whatever the definition is in the legislation, under the Cohabitation and Relationships Act, that is for maintenance and property adjustment whilst both of you are alive. And if you have separated, you have to make your application within a 2-year period, and whatever order that is made with maintenance cannot be more than 3 years. Property adjustment, it's not going to get the same weight to indirect contributions as to putting money, and they take into account, have you been compensated for the contribution you made? We could take that in account, and that's the difference in the treatment. But what you are talking about is more inheritance.
Inheritance. And let's go straight into that particular aspect of the distribution of estates when one spouse dies.
Right. So I think you're in a better
Explain,
position.
yes.
I think one is in a better position
Indeed,
there.
indeed.
So when we look in a distribution of estates, when the person dies intestate, meaning that he has left no will or no valid will, you're looking at Distribution of Estates Act sections 24, I think to 27 in particular.
Yeah.
Then when you look, but you also have to take into account what they call the family provisions part of the Succession Act, which is the only part of that act that was passed other than section 122, which says that estate duty is not payable. So let's look at the position.
Yes.
And it's a much better position. In that case, they do define a cohabitant and cohabitation relationship to include continuously living together in a bona fide domestic relationship for no less than 5 years immediately preceding the death of the deceased. Now,
and when we say preceding,
right,
before the death.
Yeah, but they have the word immediately.
Immediately.
But so I don't think they mean last week you broke up. It means that you can come 5 years later and say, yes, I was in a cohabitation for 20 years, but we broke up in 2015, and now I want, no, that's not going to fly, right? But the 5 years is the minimum period. So you have to cross that hurdle, and many people are not able to cross the hurdle. But suppose you do cross the hurdle. Now we're looking at the distribution. We look at the distribution, and it's under section 24, which is the provision that repealed and replaced the original provision under the administration. But I don't go into too much legalese. So what would happen? If the deceased dies without a will or no valid will, and he leaves issue. What is issue? Issue and no spouse. Now there, if he has no legal spouse surviving him, the cohabitant steps into that shoe. So if he died with no issue and no spouse, which includes no cohabitant, the issue will be entitled to his entire estate. Who are the issue? The children, his children, grandchildren, great-grandchildren, his lineal descendants, okay?
Yes.
Now let's go to the second situation, where he dies leaving a spouse and no issue. Now, if there is no legal spouse, but there is someone who qualifies as a cohabitant, she steps into the shoes of the legal spouse, and therefore, in a situation like that, she is entitled to the entire estate. And then we go down the line. Now, if he dies with a spouse and one child, remember now, if he has no legal spouse, but a cohabitant who qualifies as a cohabitant, what happens in a case like that, that cohabitant will get half and the child will get half of the net estate. If now he dies with...
That's child or children, so let's say...
No, I said one child.
Okay.
So that's one child. Now, if he has a spouse, which could be a cohabitant, if he does not have a legal spouse, she steps into that shoe, right? And he lays more than one child, half will go to the cohabitant, if there's no legal spouse, and half will go to the children to be divided among them. So she comes out the best.
Yes.
Now, what you were alluding to is where he has a legal spouse and a cohabitant. he dies, and there was a case like that.
Yes.
Yeah, and many cases, but this one in particular. And he
Too
died.
many.
He died with a legal spouse, but they had been separated many, many, many years, but they never got divorced, and they were not judicially separated. And he was living with this other person for many, many, many years. So it's no question when he died that she was a cohabitant. But the law says that her entitlement, if there is a legal spouse surviving the deceased, then the cohabitant only is entitled to what they have acquired, what the cohabitant has, the deceased cohabitant has acquired during the period of their cohabitation. So if he bought a house before, which is a case on point, there's a case on point, if he bought a house before, and now his wife broke up, and now he's living with this person for 10, 15 years, that house cannot be considered to be part of what they are able to obtain during a period of cohabitation. It cannot be, because it was there before the relationship started. So that's the negative for the cohabitant. But
let's take a pin, and we'll take a break right
for
after
family
this.
provision.
Yes, indeed. You are watching Strictly Legal. We'll be right back. And we are back. Mrs. Nunez-Tesheira, before the break, we were speaking about the distribution or the entitlement with respect to the common law spouse. Right. I know we last touched on the fact that if the deceased, left both his legally married wife and the common law wife, you can explain.
Yes, what I said is that obviously the spouse comes first. So if there's no spouse, then the cohabitant steps in. All right, so it's a good position to be in. But if there is a lawful spouse still alive when he dies, surviving him, and he has a cohabitant because he left the lawful spouse years ago and started this relationship, which came within the definition, the cohabitant can only take what was acquired after the relationship began. And even then, those rights are subject to the rights of the legal spouse and children. So it's not already a good position for you to be in, unless, of course, he acquired everything after he started living with you, and that puts you in a better position. But in many of the cases, a lot of what has been acquired during the legal relationship, so to speak, the marital relationship. Yes. And so what it leaves you with is not that much, and which is why many people, and there are cases that will go to the family provision, because under family provision, you stand a better chance. Yeah. Because under family provision, which is the Part 8 of the Succession Act, they give a definition of cohabitant and so on. It's the 5 years bona fide, the same thing as with intestacy. It's the same definition. But what happens in a case like that, what the law says, if he left a will, suppose he left a will, indeed, or he died intestate, but when you look at the will, he left little or nothing for you as a cohabitant. Now, it's not only a cohabitant in title, I must say that. The spouse can apply, a cohabitant can apply, child, regardless of the age, it does not. A child of the family also qualifies, or anybody who during the lifetime of the deceased, he used to make substantial contributions to them. Those are the persons that the law says, wait now. Those are people that you would have expected that he would have made provision for them in his will. So if he made a will and the person says, wait, he made little or no provision for me in this will, or if he dies intestate and you find yourself in a position as we just looked at, so you're almost getting nothing, then if you are a cohabitant, you're going to go under the family provisions. Why? Because under the family provisions legislation, the court takes into account several things. It looks at the duration of the relationship, the age of the parties, the financial resources and needs of the applicant, looks at the size of the estate, the conduct of the applicant towards the deceased. All of those things are put into the melting pot. And what happens, as happened in a very famous case where the gentleman had left his wife, had property, had acquired it before he started this other relationship. If she had gone under the intestate legislation, she would have gotten almost nothing. Indeed. But she's smart enough, and she went under family provision and said the laws of intestacy, because there was no will, the laws of intestacy did not make enough provision for me. I lived with him too many years, helped him out too much, made too many things to the property, improvements to the property, which he acquired before he started living with me. And I think when you look at all of that, you look at the duration relationship, my age, my financial interdependence on this gentleman, the conduct of the parties towards each other, the size of the estate, all of those things. At the end of the day, the court gave her a lump sum order. They didn't give her, she couldn't get the property. But when they looked at the value of the estate, etc., she got off much better under a family provision application than she would have under intestate legislation where there is a legal spouse surviving.
But in order to be classified as a cohabitant, first you have to have that application before the court, and the court has to declare you
Absolutely.
a cohabitant
Absolutely.
before applying for
Exactly. So there'll be a little bit
distribution.
of, can I just say, there will be a little bit of wrangling between the two lawyers. Say, listen now, don't force me to go to court and make an application for family provision, because I have a very good case based on what the court looks at to determine whether I should get some part of the estate if he didn't leave anything for me in the will, or if the intestate laws are not good for me because he had a legal spouse, and that's how the law is, whatever it is. Don't let me go to court, because if I have a very good case, you know who's going to have to pay for it? The estate. The estate, not me, the estate.
Yes.
So usually people try to settle these things outside of court and say, okay, let's come to some arrangement as what is acceptable to both parties. But if we can't, the only way, as you're right, the only way that is going to happen, you are going to have to make an application, and within 6 months after the grant has been obtained, there's a time limit. So you can't just sit down on your thing and wait and say, maybe I'll think about it. No, you can't think about it. You have to apply, because as it is, the will take effect as is, and if you don't apply, the intestate laws will take effect as is. Family provision allows the court, in effect, to alter the provisions of a will and alter the provisions of intestate law. That is what they are doing when you make an application that is successful, and we are only focusing on the cohabitant.
So it's a very, very strict test when it comes to cohabitational relationship, rather than a legal marriage.
Yes, but you know, it's a strict test in one sense. In another sense, it may not be, because there are cases, when I had to writing my textbook, as you mentioned, and you're looking at the case law, especially from Barbados, they look at other things. It's not as rigid, but you've got to satisfy the 5 years.
Indeed, Mrs. Nunez-Tesheira, I think we need a second part of this, because it has been a lot, and there's so many things to discuss with respect to estates particularly.
Yes.
So thank you so much for being a great guest, and I'm sure you will be back.
Yes, and don't forget, I should have brought my book along.
Yes.
Because I'm always not that very good about promoting it.
I know, but we shall put it up on the screen at the next occasion.
Right.
Indeed. So thank you very much. You have been watching this episode of Strictly Legal, Common Law Spouse, the Rights of Common Law Spouse in Trinidad and Tobago. See you next time. Good day.